We were recently asked about preliminary hearings because some of their loved ones had charges, had been arrested, and now were awaiting the preliminary hearing. So they wanted to know what happens typically in a preliminary hearing. Now, my experience is in California. Some states might have little variations, but mainly what a preliminary hearing, and the judges and the attorneys are just going to call it your prelim. What they're looking for is there probable cause? Was there enough evidence that if it went to trial, that this person would probably be found that he was either involved or he and she were involved? So there's some evidence to link them to that case, either as a defendant or in some way the prosecution was looking to attach them to a certain case. So really, that's what the preliminary hearing is about. It's for the district attorney that he is going to be bringing the evidence, the basic evidence. Now, they're not going to get into all the long evidences that might be found in a trial. You might have some expert witness, but primarily it's much shorter. Most of the preliminary hearings that I've seen only take a couple of hours. I do know of some that have taken up to 2 days. I think that's the exception rather than the rule. Most of the time, the judges are just pushing things through. In my experience, they'll do the preliminary hearings earlier and then have other court cases that might start at 10 or 11 or something like that. So they'll do prelims first and then they'll go in and have other hearings. But there has to be an examination of whether there is enough evidence for a criminal proceeding. So I'm going to give you a PowerPoint presentation on this so that you can see it on the screen and you have a good understanding of everything that's going to be involved for a preliminary hearing, whether it's yours or friends or loved ones. Gives you a little bit of an idea of what's going to take place. What is it that you can expect if you are called into court in a preliminary hearing? We're going to be discussing preliminary hearings in criminal courts. So now let's ask the question, what is a preliminary hearing? Preliminary hearing is not a trial. It doesn't decide if you are guilty or innocent. It's there simply to see if there is enough evidence, what they call the prima facie case, to see if there's enough evidence to hold that person over for a trial. So that's the purpose of a preliminary hearing. It's held primarily in criminal courts, and it's going to help prepare for these criminal proceedings that are going to go on. So we'll be discussing some of those things, and this is just to give you some tips how to handle a preliminary hearing. They'll call it a prelim as well. It simply means that the prosecution has to show there is enough evidence to go to a trial. That if it goes to trial, that there's the possibility that this person could be found guilty. In thinking about what is a preliminary hearing, this is where a judge looks at that probable cause. Is there a probable cause that exists to connect the defendant to that crime? Many times the officer will show up and will have to say, I was called on such and such a date at such and such a time, and here's my report. And they might refer back to their report. So it connects the defendant to the crime that was committed in the case that's being tried. So the judge will look at all of that the prosecution have. He's going to look at all of the evidence the prosecution has to find if there's enough evidence to believe that the defendant probably or could have committed this crime. This part will take less evidence than what will happen in a trial. That's why oftentimes a preliminary hearing is maybe 2 hours. Sometimes they'll do multiple cases depending upon the scope of the trial. if it's considered a very high profile criminal case, if it's a murder case, something like that, then it will probably take longer. If it's something that they consider a lesser case, then they might even hold a two or three preliminary hearings at the same time, because the judge will normally do these. From my experience, the judges often do this before they have their regular trials that will start at like 10 o'clock, 11 o'clock, and they'll do the preliminaries maybe around 8 o'clock or something like that in the morning. Still, the prosecution has the burden of proof. They have to demonstrate there is credible evidence to justify the charges that are being brought forth. And sometimes a judge could lower it if he doesn't feel like there is the evidence, or will throw it out, or tell the prosecution, the district attorney, to come back with another charge. But normally, most of the time, my experience is, and understand that the DAs, the prosecution, and the judges are already on the same side. It's pretty much stacked against you. So you definitely need a good attorney at this point. So, what happens in a preliminary hearing? Well, there's first the probable cause standard. The probable cause standard is that the prosecution has to supply enough evidence and that a logical person would conclude that the defendant had committed this crime. And so that's the standard, the logical person. There also must be the presentation of evidence. You'll be given that. If you're the defendant, you will be given a list of what the discovery evidence is. So during the preliminary hearing, both sides can present evidence, but this evidence kind of has less strict or less stringent rules than during the trial. So you might get an expert witness from the prosecution, but their testimony is going to be much, much shorter. And then there will be, as I said, witness testimony. So not only the physical evidence, but a witness, and that might be the law enforcement officers. The victims might be called in, whoever made the call initially that got law enforcement involved, or how did law enforcement get involved. All of these things come out through the witness testimony because they're trying to show a progression. How did this happen, and what is the logical progression in your case? And then also, how long is this going to take? Like I said, usually preliminary hearings are less than 2 hours. I have seen some, especially murder cases, that have gone on. They're much more complex, and they've gone on for as much as 2 days. Usually they're shorter duration than a trial time. So just depending on that particular judge and the charges. What do you need to do as a defendant in a preliminary hearing? We want the most favorable outcome, absolutely. And nobody wants to sit in jail. And hopefully you got bail. Maybe if you're watching this because you've gotten bail, or maybe as a loved one for a family member, you're getting more information to help your loved one that's sitting in jail awaiting a preliminary hearing. And it's always the best to get the best attorney you can afford. If you can only afford the public defender, wonderful. There are some public defenders that are excellent, but I don't recommend any particular attorney, because you want an attorney that is going to be experienced in the field of which the charge is. In other words, if this is a drunk driving case, you want someone who has experience in fighting drunk driving. If this is a murder case, you want someone who has experience in criminal court fighting murder cases. If this is a sex crime, or let's say it's a spousal abuse, then you want an attorney that knows about that type of case and how to defend it, and has a record of defending it. Now, you might get someone right out of school and they're gung ho, and you could take a chance with them. But again, it's getting the best attorney that you're comfortable with and will do the best job for you. An attorney is a great help. He or she will be a lifesaver to you if you have a good one. You are also able, as a defendant, to review the discovery materials. Now is the time to consider someone else beside you. Maybe you're sitting in jail or you're waiting for this horrible day of preliminary hearing and your stomach's in knots. But think about your loved ones. What are they going through? Maybe now's the time to think about taking a deal if that prosecutor has offered you a deal in order to make it easier for your family. Maybe now's the time to think about your family. And if you took a deal, how much easier would it be on loved ones and others, not running up big bills, big expenses? What about them? What are they going through? Don't think about yourself just because you're sitting in jail. And I tell you, I was there. I wanted out. I know what I'm talking about. Although they never gave me an offer, a plea deal. However, think about someone else beside yourself at this time. So, for that most favorable outcome, that's why I say if they're offering you a deal and you know you're guilty, sometimes we don't want to admit that we did it. We want to try to fight it because we don't want to pay the consequences. Maybe it's better to take the deal and accept the consequences. If that's going to help your loved ones, then that's something you ought to give very high consideration. The other thing you want to do is prepare for the witness testimony. Who's going to be speaking against you? In a spousal case, it'll be your spouse. It'll be the officer. It'll be whoever had to document the marks or the cuts or the bruises or physical damage that happened. Prepare for witness testimony. Understand that the law enforcement officer is required to be there. They will be there. Victims also are going to serve as witnesses, and they may present their testimony during these prelims. And a defense attorney is permitted to cross-examine these witnesses to see if there is true evidence. And remember, they're trying to just say there is enough evidence. It's a prima facie case. So prepare for that. Think about the possible outcomes. That's why you want to be completely honest with your attorney. There is attorney-client privilege. You can tell them the truth. Be very truthful. Don't hold anything back, because your attorney is going to need to develop cross-examination questions when witnesses are ready to come up to testify. You can help your attorney in this case. And preliminary hearings frequently focus on the judges evaluating a witness to see if they're credible. And I'll give you an example. I knew of a man, he was actually in another state, but there was a divorce case going on, and who was going to get custody for the children? The wife was saying that this man had sexually abused his son. He was in another state. She had been taking crank, and the judge just found that she was not credible. So that got it thrown out. But understand the possible outcomes. So by working with your attorney to understand what the scenarios are, understand what it is that you may be facing. You could be facing life. Are you facing the death penalty? Are you facing probation? Are you facing maybe a few years or months in prison or jail? What are the possible outcomes? Every charge has specific boundaries where they can't charge you over this or they can't charge you below that. Think about what are the possible outcomes. Could you get probation or 21 years? Or could you be doing a life sentence? Those are all things that you have to be prepared for, and you have to be focused on these issues that are at hand. And now, when you prepare to stand in court, let me tell you that when you stand in court, your case is not going to automatically be dismissed. If the prosecution believes that they have enough evidence that they're bringing you to trial, they have the experience to know that they'll probably get it. Because in California and in most states of the union, they're getting upward of 95% conviction rate. So they will be trying cases that they know they can get a conviction. Don't think that, well, my case is just going to get dismissed. While a dismissal is possible, my experience that these cases do go on to trial. Or that you think, well, I have to prove my innocence. The defense does not have to prove innocence at this stage. And that's something that you should be thinking about. The burden of proof is on the prosecution to show probable cause. However, be thinking about you do need to prove your innocence, even though that's not the law, but that's the real fact of the matter. You will have to show I did not do this. And then also, some might think this is my only chance to win. The preliminary hearing's not the last word. Even if you are held to answer, and that's what the judge will say, if he believes there's enough evidence to connect the defendant with the charge, there may be opportunities that the attorney has to challenge that prosecution's case before you go to trial. And the prosecution might recognize that they have a weak case and they may offer you a better deal. But that's why a preliminary hearing very much matters. It's going to test the prosecution's case, and it helps you review the evidence. You hear the witness testimony before the trial, so you can also understand what's going to happen with pretrial motions and maybe later even appeals. Your attorney can push that the charges be reduced, and this would be the time that they would do it. So understand the possible outcomes. So your attorney can ask for a lesser charge, or they can ask for it to be dismissed where there just isn't enough evidence. So let's sum it up. You want to consider how you look to the judge. You want to dress nicely. If you have tattoos, wear a long sleeve shirt. Dress as properly as you can for your preliminary hearing. Remember, the judge deals with people all of the time, and he will not listen to all of the drama. Doesn't want to hear all your past. They want to deal with this case, and they're going to look at you. And how the judge looks at you will have a bearing upon this case. When it goes back to the judge, if it goes to trial, comes back to this trial judge, what he thinks of you will make a huge difference. Don't try to bring in all the drama. Don't try to scam him. Don't try to say, well, I can talk my way out of this. These judges have been around a long time. They've been trial attorneys. They know their stuff. You're not going to just be able to get by with them. So how you impact the judge is going to have a great impact on your case. Not only that, I said it earlier, but be honest with your attorney. Be forthright. Sometimes you did it. Be honest. Tell them every aspect of the case, not just that which puts you in a good light. Tell them about where you really messed up. Tell them about everything that you did, even if it puts you in a bad light. But that attorney needs to know so that he can ask the right questions and bring it around to the best benefit for you. I hope this has been helpful. I hope that if you have other questions on preliminary hearings, again, I'll come back to if you've got a good attorney, they're going to make a huge difference and a big help for you. I hope that works. I hope that it helps you change your mindset, because sometimes we get in trouble with the law, and it's the Lord trying to work to get us to wake up. It's God trying to work on your life to make you think about, what have I been doing? And I can share with you in other videos about the grace of God and the help of God, because at this point you need God's help, and Jesus Christ is there as a Savior to help you in all of those ways. May God bless you as you go through this time.